when you get a drafting assignment, drafting is the last thing you should do. There's a lot of preparatory that goes into drafting. If you supposing you're asked to draft, your client is interested in purchasing a piece of land, and you have to structure the entire transaction. Give some thought to the entire structuring of the transaction. Look up the Stamp Act. See if you're serious about a career in real estate. Stamp Act and Registration Act. These two acts, know it like the back of your hand. And by that I don't mean you should know the rates and each and every article and each and every section. Know the basic principles of law. All these Stamp Acts. Now we have the Indian Stamp Act. So in Maharashtra, Gujarat, Karnataka, these states also have their own independent state Stamp Act. But if you study, it's many places have, I think in Punjab and thereabouts, what they have done, they have retained the act as it is. Schedule 1 of the act gives the rates. So what they have done, they have said, okay, we have no issues with the substantive provisions of the act. What they do, they amend the Schedule 1. So they don't have an entirely different act as in case of Maharashtra and Gujarat, but they have a different Schedule 1. Now, even when you do a comparative analysis of all the Stamp Acts, you will notice the principles are the same. Now, there is a very, for example, Section 4. What does Section 4 say? Section 4 says that in a sale transaction, one document is to be considered the principal document, which should be stamped fully. So usually we consider a deed of conveyance to be the principal documents, and we stamp it at, as a conveyance at 5%. All other documents should be incidental to the principal document, can be stamped nominally. So it's a very important concept. Therefore, supposing you tell your client, we will consider the agreement for sale the principal document, and you pay 5% stamp duty, your transaction falls through. What do? So all these things you have to think before getting into drafting. You may be drafting a loan agreement, a share purchase agreement, a debenture trust deed, in which case look up the relevant, if it's a debenture trust deed, look up the Companies Act, look up the relevant, SEBI regulations. If it's so going back to the example, I think we were talking about an agreement first, but development agreement. In Feb, the Bombay High Court passed a landmark judgment. Now, why is it important for you to know what your client intends to do with the land? Only then you will be able to put relevant clauses in your document. So if it intends to put up a factory, there'll be different representations. If it's he intends to just put up a residential project, then there'll be different implications. So all these, before you start drafting, there's a lot of groundwork to be done. Look up precedents. Now, there are a lot of textbooks. I think, practicing advocates have a copy of Tijoriwala in their office, a copy of deed and documents by Divya in their office. But there are wonderful precedents available on the net. I think between the time I cleared my LLB and now, Google has become Googleshwar. Study these precedents. Note what, there are always certain clauses you can, which are so beautiful, wonderfully drafted, and they contain a thought which you had not thought of. They contain an idea which you had not thought of. So you can always incorporate those clauses in your own draft. Now, that is as far as doing the preparatory work is concerned. See, unlike a movable, if I have to sell a movable to you, what do? I pick up this mobile, I hand it over to you, and that is done. You pay me the money, the transaction is complete. You can't pick up a piece of land and similarly just hand it over to your purchaser. And that's why we have a concept of vesting document. Now, recently, my client would refer to anything and everything as an agreement. So that's when I realized that, sometimes it is the business, especially those of you who work in corporates, you would realize that the legal team understands the legal nuances, but the team which actually interacts with the other side is the business development team. And the business development team obviously would not know these legal nuances. So a document in a ownership rights can be transferred to another party, a land, immovable property can be transferred to another party only by means of a registered instrument. An agreement is not the final document. It's not the vesting document. Is what does an agreement do? An agreement gives you the right to seek specific performance in a court of law. So what does it do? It doesn't, even if you pay 100% consideration under an agreement, it does not make the purchaser the owner of the property or the lessee, the actual lessee of the property. It gives the other party the right to seek specific performance, or it gives the other party to knock the doors of the court and seek whatever is contained in the agreement. However, once you have a conveyance in your favor, or a sale deed, a gift deed, a sale deed, gift deed, a lease deed, these are instances of vesting documents. Once a deed of conveyance is executed in your favor, you become the owner of the property. So it is, if symbolically, if the land was something like this, a book, when you do a deed of conveyance, you actually pick up the land and tell the owner that now tell the purchaser, now you are the owner of this piece of land. Therefore, you will notice that in all the revenue records, your name will not be entered in the main column as the holder of the property unless you have a sale deed in your favor. Revenue authorities will not act on an agreement for sale in your favor. So I hope you have understood the difference between an agreement and a vesting document. Any doubts? We are clear, Abhijit? So have you understood the difference between an agreement and a vesting document?
Yes, ma'am. I got the point.
Before we talk about start demystifying and analyzing a vesting document like a deed of conveyance, I would like to just brush up the very concept of ownership. What is meant by ownership? Ownership can also be viewed as a bundle of rights. If you are the owner of the property, you have a right to use the property. You have a right to, so what is called in Latin, jus utendi, you have a right to possess. Now, possession is 9 point out of 10. Then you have a right to, you even have a right to destroy the property. So the reason why I emphasize the right of destruction is to highlight what it is to be an owner of the property. See, an owner can transfer any of these rights in favor of another person. When an owner gives his land on lease to somebody else, or gives his property on lease to somebody else, what is he doing? He is parting with the right of possession. The lessee has the right to be in the possession of the property. However, if a lessee destroys the property, if he demolishes the building, or he does anything very damaging to the building, the owner can step in and immediately terminate the lease and take back his property. So even though possession is 9 point out of 10, a lessee can never be the owner of the property. Then what is this? So of course, right to transfer property is a very essential right. If you can't transfer your property, then it loses its value. Today, properties, and therefore properties in Bombay are more valuable than, say, a piece of land in a village. Why? Because if you want money, you can immediately liquidate it. You can sell it. You can sell it in the open market. You can mortgage it. So all these right to dispose property is an essential element of ownership. Right to exclude others from use of your property. When you say this is my property, that means you can sue somebody else for entering your house without your permission. It amounts to trespass. It's a very serious offense. So now when you look at a vesting document, a typical deed of conveyance, believe in 2003, when I think I read 2004, I read a deed of maybe much later. I think I did my LLB in 2006. So I was interning at that time. And when I first read a deed of conveyance, frankly, I didn't understand a thing. At that time, people used to not put captions in their documents. And that's the worst thing you can do. especially when it comes down to banking and finance documents, because sometimes these banking and finance documents go into, you will have your, say, debenture trust deed, you will have your pledge agreement, then you will have certain undertakings. So at the end of the day, if you were to compile all the documents, intercreditor agreement, in a banking and finance transaction, you can actually, you end up with a stool. You can sit on the whole lot of documents. The amount, the volume generated is the volume of, just to give you a sense of the volume of documents. At that time, it's really helpful to captions. Captions and headings are really helpful. Anyways, a conveyance is never more than 8 to 10 pages. So way back in 2006, when I came across this document without captions and in a typical format with that typical language, I didn't understand a thing. And eventually I learned the importance of captions. I eventually also learned that a deed of conveyance is the very embodiment of the various elements of ownership. And this is something we will discover as we. So this is what your typical deed of conveyance is. Okay, you begin by writing the place of execution, the date. This too is important. Then the parties. Now your document can change depending on. Now, if your parties are individuals, then there is a different set of wordings that you would use. If your party is an HUF, if the property is owned by an HUF, then there's a different set of wordings you use. Similarly, same goes for firm and corporates. So in case of individuals, you usually write, you say, I can see Ragini's name in front of me. So supposing Ragini is the vendor. Now I know Ragini is the seller. So I will call her that Ragini, this agreement is made by and between Ragini, age so-and-so, occupation so-and-so, PAN. It's important to state the PAN card in real estate documents. Hereinafter referred to as the vendor. And then I'll go on to say which expression includes her heirs, executors, administrators. Usually we don't say assigns when we are talking about deed of conveyance. But the modern day trend is to mention assigns now. However, if it's an individual, if it's a company, I would not say that ABC Limited, having its registered office at so-and-so place, is hereinafter referred to as the vendor, which expression includes its heirs, executors, administrators, and assigns. Why? Because corporates don't have heirs, corporates don't have executors, corporates are not, they have perpetual lives. Corporates don't, die like natural persons. So where is the question of heirs, executors, and assigns? So what do you write? You write successors and assigns, because a corporate can have successors and a corporate has the right to assign the property. A very typical case is that of an HUF. Now, what is an HUF? The idea of an HUF too has transformed since over the last 15, 20 years. At one time, women had no rights. Only, grandson, male co-partners had rights in HUF property. Whatever be the case, you must state the karta. So-and-so HUF, Gavit. There's one Mr. Punya Gavit. I can read his name in front of my screen. So if I say Punya Gavit HUF, represented by its karta, that is very important. Now, the karta cannot alienate property for any reason. See, alienation of land is a serious issue. It may be the case that after alienation of the land, the HUF doesn't have any other immovable property. There are only certain limited instances in which a karta can alienate the HUF property. And what are these instances? One instance is that of for the benefit of the family and the benefit of the estate. These averments therefore become a must in the document. Otherwise, the transaction can be set aside. So if you are representing the purchaser, you insist on writing, and when you're dealing with an HUF property, insist on writing that the sale is for the benefit of the family and for the benefit, the sale is for a legal necessity. and for the benefit of the HUF and for the benefit of the HUF estate. Similarly, if it's a corporate, again, as I mentioned earlier, in case of corporates, if the property you are dealing with is substantial asset of the corporate, then it's not that the board of directors can get together and sell the property. An extraordinary general meeting has to be called, conducted, and then certain resolutions have to be passed. So as I mentioned, there's a lot of preparatory work that goes in before you come to the stage of drafting of any document. Forms. These days, there's a trend of just mentioning Messrs. ABC. There is no Messrs. ABC. So when we draft our documents, we make it a point to mention the partners specifically, because see, unlike a corporate, a firm is not does not have a distinct what do you call it? It's not separate from its members. It does not. A firm is a partnership is an arrangement between individuals to come do business together. So ultimately, it's very important for you to know who the partners, individual partners are. And therefore, when we draft our documents, we make it a point to say that Miss Aparna, Miss Komal, carrying on partnership business in the name of Messrs. A and K, having his registered office, principal place of business at so-and-so place. So as I said, even the title clause, there's a lot of thought process that goes behind drafting of something like a title clause, something as simple as a title clause. Now we go on to recitals. What do you understand now? All of you must have seen, very old documents going back, as I said, in 2006. I came across a document which just went whereas. And I said to myself, what is this whereas? I had enough of this. And what is the difference between whereas and the, now this deed witness it? Why do we separate the document in these two parts? And how do we decide on, what to record as background and what to record as what comes in the actual document? So anybody would like to share his or her thoughts? What do they understand from recitals?
What I believe, recital contains an account or a repetition of the details of some act or a proceeding of the fact or on the fact, particularly a legal document, I believe.
Okay. So, 20 years ago, when people would start their document with whereas, the intention was to record not the actual bargain between the parties, but the background leading to the deed of conveyance. And it is for this reason that nowadays, instead of writing whereas 100 times, people just write whereas once. In very advanced documents, especially when you deal with foreign clientele, you will notice that the word whereas has been replaced by the word background or recitals. And that is exactly what recitals are. Recitals are nothing but background, things which happened in the past, things which have led to the deed of conveyance. So here you will typically talk about how the vendor became the owner of the property. It may be by virtue of inheritance. It may be by virtue of, your vendor might have bought this property 20 years ago and he no longer needs it. So you write, and it is for this reason sometimes all the representations and warranties are captured under the heading recitals, because you would like to highlight that the vendor made these representations to you and therefore you are purchasing the property. Had the vendor told you that you cannot set up a factory on this particular piece of land, then you would not have bought it. For example, right from Kanyakumari to Gujarat, there is a strip of land which has been notified as eco-sensitive zone. Now, in eco-sensitive zone, you cannot put you can put some nominal construction. You can't put factories. You can't put up heavy industrial. You can't construct mills. If you knew that this particular piece of land is in an eco-sensitive zone, you would probably not touch it. Sometimes your land may get notified under some Forest Act, Wildlife Protection Act. You never know, and therefore we usually, when we take the mandate of drafting a deed of conveyance or sale deed, we put all these representations and try to ascertain the nature of the property. Typically in all law firms, the client first approaches the firm and requests the firm to prepare, to do a due diligence, title due diligence, which is followed by the drafting of documents, be it deed of conveyance. It is up to us to advise the client which is the best way to structure the transaction. But I hope you guys have understood what goes in recitals. Then comes the operative part. Now, in operative part, we start with consideration, because money is, I mean, let's face it, money makes the mare go. So even when we draft our documents, invariably we first capture the actual bargain between the parties. What are they intending to buy? What are they intending to sell? And the price for the same. So that is where you, and see, conveyance is the last document. Once you actually end up giving control of your property once you do a deed of conveyance or once you do a gift deed. Many people think, and I have come across such instances where the donors are invariably retired parents, aged parents. They feel that once they do a gift deed, they still have some sort of say on the flat, which is not the case. Once you do a gift deed, it is done. It's a fait accompli. You have lost control over the property. You have vested ownership rights in the donee. He may be your nephew, the donee may be your son's daughter. So now in a gift deed, there is no consideration. So a gift deed will never have will never have these lines in consideration of a sum of rupees so and so. Why? Because a gift is given, it's an exception to the rule that everything should be backed by a consideration. What does TOPA say about a gift? That a gift is given out of, it should be, it's given by the donor. It should be accepted by the donee. And it is for this reason we insist on making donee a party to the gift deed and recording the acceptance of the donee. And instead of writing in consideration of sum of rupees so and so, what do we write? We write out of natural love and affection that the donor bears towards the donee. The donor is gifting so and so property to the donee. Now, this was, as I said, in 2006. This was the sort of this long Ramayana got to me, and I said to myself, "Good heavens, what is this?" When you describe the land, you try to put in as much as possible: plants, trees, paths, privileges, anything belonging to the land. Remember, your deed of conveyance, as I said, is the vesting document. Everything will turn around this document. So you would not want to miss out on anything. In fact, if you are a developer, when our client is, so many of our clients are developers, we make it a point to write FSI, TDR. We take a representation from the owner that he has not converted any FSI appurtenant to the land in the form of TDR. Otherwise, you would not want to be. See, today, what is what adds value to the land? It's development potential. So if the vendor has very smartly got rid of the development potential, then your land may be worthless. So we record all that. Wells, and if supposing there's a swimming pool, we specifically mention swimming pool. See, what is general? These general words will cover whatever, easements will cover right of way. There's no doubt about it. Members and appurtenances whatsoever will cover FSI. However, this is your title document. Based on this document, you'll have to deal with others. It's a public document. We'll have to deal with other authorities. So whatever can be specified, whatever can be identified specifically, capture it in your document. Then the next clause, and therefore it is called the parcels general words clause. Now in the next clause, we go to estate clause. I'm talking in terms of title. There we were talking, in the first part, we were talking about this captures the physicality of your property. And this captures the legal aspects of the property. Whatever rights they may be in law or in equity. In equity, you may have a right. So, for example, the land you buy, there may be a covenant attached to the land, there may be a garden next to your piece of property, and your previous owner might have acquired certain rights with respect to the garden, that he will have the right to enjoy the garden. And this does happen in common layout. Although you are not the owner of the garden, but under law, thanks to the acts of your predecessor in title, you have certain type of right to the garden. So that's where this clause helps you. Now we come to habendum. Habendum is this portion, to have and hold. I was actually, as I said, when I first read without any captions, the deed of conveyance, and I said to myself, what is this to have and hold? And I considered myself to be fairly well read in English language, and this completely, when Malvika approached me and she asked me what is it I intend to do, I thought about it for a while, and then I told her I intend to demystify a deed of conveyance. So now we know that this particular part of a deed of conveyance, which opens with the lines with the words to have and hold, means habendum. As I said, a deed of conveyance, what are you doing? If it were a book, you are, by virtue of a fully stamped and registered deed of conveyance, you are actually handing over the book to the purchaser. Then there is a declaration of use that so this is how now we are coming to this is the first slide, that all the incidents of ownership. You have the right to use the property. Declaration, so you take a declaration of use from the vendor. Of course, any uses will always be subject to payment of taxes. There's a Benjamin Franklin saying that the only certain death and taxes are the only certainties in life. Then right to convey this. So this is as far as the property and the description of the property is concerned. Now we come, the next part of a deed of conveyance deals with various covenants. So we take different covenants from the vendor. One of them is right to convey. It may be possible that the vendor, as I said, if it's a corporate, for example, it will have to, if the land happens to be substantial of the company's assets, then the vendor should have obtained the permission, or should have obtained the resolution, passed a resolution, general body resolution, in which case a board resolution will not be of much use. So the right of convey, you're taking a covenant from the vendor that all that is necessary. Under law, he has done it, and he has the power to, and the authority to execute, to convey this property to you. Then we go to quiet enjoyment. So as I said, jus possidendi, the possession is 9 points out of 10 in as far as real estate is concerned. So here you take a covenant from the owner, that from the vendor, from the seller, that you as the purchaser, you are entitled to enjoy the property peacefully without any interference from him. There's no infighting between his sons, children. If it's an HUF property, you'll be allowed, somebody will not come squatting there that I'm a co-partner and I don't approve of this particular sale. Now, when we talk about possession, we just don't talk about physical possession. The right to receive rent too is it's an incident of ownership, and it's also an incident of possession. Because you were in possession of the property, you could give it out on rent and enjoy the fruits, or enjoy the profits from the land. So that is as far as quiet enjoyment is concerned. Then covenant against encumbrances. Now this is another covenant that we take from the vendor. What does it say? See, even if you read the Transfer of Property Act, you will realize that unless there's a contract to the contrary, the seller covenants gives you a guarantee about the title. And a deed of conveyance just mirrors that obligation of the vendor. So much so, see, if it were an sale on as-is whereas basis, then you would delete this covenant. So this is a textbook standard deed of conveyance. All these clauses are a must in a standard deed of conveyance. But if you are doing a sale on as is where is basis, what does as is where is basis mean? There are encumbrances, there are encroachments. I'm the vendor, I'm selling it to you, you are the purchaser. I'm not responsible. You have come, seen the property, done your due diligence. I'm not going to get rid of the encroachments and tell you that you will get a very pristine piece of land. It is your hassle. You may be a developer. You are in the business of dealing with encroachers. How you deal with the encroachers is not my lookout. In which case, you as the vendor will not give this covenant against encumbrances, because this here you are not only saying that I'm giving you the premises clear of any encumbrances, but you are going ahead and telling the purchaser that should something come up in future, I will indemnify you. So you are taking on a financial liability. So that is the significance of this covenant. Then further assurances. There was a time, so 2006 was a wonderful time, to start your career in real estate. And the reason why I'm sharing this with you is because we had townships. I think after that, real estate market has been so bad that we haven't seen, I had the opportunity of working on Lavasa. We haven't seen another special hill station township. We haven't seen activity in special economic zone. Nothing to match what was there in 2006 and thereabouts. So at that time, what happened is people also got greedy when they saw these big corporates amass so much of land for integrated townships. What they would do, they would refuse to cooperate. Now, what happens in your deed of conveyance? Your deed of conveyance is done. Based on the deed of conveyance, you will go to the talati and update the revenue records. See, unless you're in Maharashtra, what we call Satbara Utara, unless your name is on the 712 extract, or the property register card. So in Pune, Mumbai, city areas. In city areas, the revenue authorities maintain a property register card. So unless your name is reflected in the property register card, the municipal corporation does not approve your plans. Now, what do you do if the vendor, refuses to cooperate with you? Because the revenue authorities have a procedure. Unless the vendor gives his NOC, so they first give what they call Vardi notice to the party whose name appears on revenue records, the existing owner. And if there is no objection, only then they enter the name of the new owner in the revenue records. This is the standard procedure followed by all revenue authorities from up north to down south. Now, if he acts funny, what do you do? So therefore, we take a covenant from the vendor regarding further assurances. What does this mean? This means post-execution of the sale deed, whatever is to be done for perfectly and absolutely granting the property to the purchaser, he is bound to do it. These days, in my own, just yesterday, we finalized a deed of conveyance. If we can foresee something, as far as possible in any document, be specific. Now, we clearly could foresee, and anybody will foresee, that after the deed of conveyance, the revenue records have to be updated. Now, in this case, our client happened to be a developer. So we specifically put in that the vendor will sign all forms, indemnities for updating the revenue records, including 712 extract and form number 8A. These are very basic revenue records. Then what else do you see? So sometimes over here itself, we record that, to enable, once a man sells his land, sells his property, he is impossible to trace. And therefore, the practice of executing a power of attorney along with the deed of conveyance came about. So after the deed of conveyance, if you as the purchaser, you wanted your project to go ahead seamlessly, what would you do? You would ask the vendor to execute a power of attorney. So this is as far as the very basic structure of any typical deed. It's a textbook. You have just gone through a textbook precedent. You'll open a Tijori Wala, you will see the same things. In addition to these clauses, depending on your on your property, you'll put a covenant for production of title deeds. See, when you do a deed of conveyance, you are the owner of the property. The purchaser is the owner of the property. The purchaser should have each and every document with respect to the property. So all the past deed of title deed should be handed over to the purchaser. But it may so happen that the seller has is a big landlord. He has some 20, 30 acres with him, and you are buying only 5 acres. So for 5 acres, and the title document of the entire 20, 30 acres is the same. He acquired this 30 acres under just one, say, sale deed way back, say 1960s or 70s. Then what do? You can't tear up his sale deed in different parts. You can't say that. So what do? You take a covenant for production of title deeds from him, saying that, okay, I know you have the greater part of the land, but anytime I need the original, you will produce it. You will produce it before the court. You will produce it before any revenue authority. At any given stage, you will produce the original deed of title. Then there's a covenant for grant of right of way. Now, it may so happen this 5 acres is part of a larger land. To come to this 5 acres, there's no direct public road. There's no direct access to the land. You have to pass through the vendor's property to access your 5 acres, in which case you will incorporate a right of way in your deed of conveyance. Now, what are these covenants running along with the land? See, if you look at the definition of what is immovable property is not just actual land, but any benefit arising from land. So your land has, as I gave you the example, you may be entitled to go enjoy the garden in spite of not being the owner adjacent to your land. That right may be a covenant running along with the land, which means it's not only every person who's the owner of the land that you have just purchased will be entitled to the benefit of going to the garden and enjoying himself there. So this is an example of covenant. Very typical example of covenant running along with the lands are what, these days there's a fashion of incorporating community-based covenants. So vegetarian and all those covenants are covenants running along with the land, in which case you can't do much because they become fastened to the property itself. So there is a clause for payment of stamp duty, registration, brokerage, then witnesses. Now you would wonder what is there about in testimonium clause. Remember this Transfer of Property Act defines what attestation is. That means at least you need 2 witnesses to attest your final documents, vesting documents. So we real estate practitioners are so scared of, Transfer of Property Act is a very basic act. We're so scared of the Transfer of Property Act that even if we draft an agreement, we make it a point to have 2 witnesses. Whether 2 witnesses are required for an agreement or not there's no law which says that you need 2 witnesses as far as an agreement is concerned. But there's definitely a law, and that is the Transfer of Property Act, which says you need attestation means 2 witnesses. So as a thumb rule, when we are doing real estate documents, we make it a point. So in the presence of one, this is your witness 1, and this is your witness 2, and the party signs. Now, in spite of describing the property in the main body of the deed of conveyance, invariably there is a schedule, and what we capture in this schedule is what is required from the point of view of the Registration Act. So under the Registration Act, you have to write the boundaries. The idea is the property can be identified without any ambiguity. So the Registration Act says you have to state the area, state the CTS number, village, taluka, and it is for this reason. And sometimes from a stamp duty perspective, we even write the details of the building, whether there is a lift or not. Now you would wonder, how does it matter whether there's a lift or not? Because the ready reckoner rates have a different formula for assessing a building with lifts and for assessing a building without lifts. Then we make it a point sometimes to write the age of the building or when the occupancy certificate was obtained. And you would wonder why? How does it matter? Well, the idea is you're entitled to depreciation and the stamp duty. So if you show that it's an old building, then your market value comes down and you have to pay less stamp duty. So this is as far as a typical deed of conveyance is concerned. On the matter of power of attorney, there are just a couple of things I wanted to share. One is, people often wonder what is the law governing power of attorneys. Now, we have a Power of Attorney Act, but frankly, the substantive law is not the Power of Attorney Act. The substantive law is really the Indian Contract Act, which the part of the Indian Contract Act which talks about agencies. Because every time you make somebody in a real estate transaction your constituted attorney, you are actually creating the relationship of a principal and an agent. He can represent you and he can carry out construction on your behalf. Now, if you look at that portion of the Contract Act which deals with agency, you will notice that there are specific sections on what happens when the agent has an interest in the immovable property. So we record that. Usually such power of attorneys are executed along with development agreement, because what happens in a development agreement, the landowner continues to be the landowner of the property. So all the permissions are obtained in the name of the landowner, but actual development work and construction work is done by the developer. And therefore, the Stamp Act 2 says that if you haven't stamped the development agreement fully, then the power of attorney must be stamped fully. You get a set off. Now, what are the implications when in the recitals of the power of attorney? Therefore, it becomes very important to say that this power of attorney is being executed pursuant to a development agreement or pursuant to a conveyance. Firstly, you can then take advantage of that set off in stamp duty. Secondly, you are highlighting the fact that you as the constituted attorney have an interest in the subject matter of the agency. So you have an interest in the real estate property. You're not becoming a constituted attorney just to do some clerical and ministerial job. You have an interest in this particular property. So that's how it becomes irrevocable. When we say an irrevocable power of attorney, it actually means the agent, that the constituted attorney has an interest in the matter, in the subject matter of the agency, and therefore the agency cannot be terminated at the whims and fancies of the power giver, of the principal. So this is as far as the power of attorney is concerned. Be very careful, because see, once upon a time, conveyance attract a very substantial stamp duty. So people used to not execute conveyances. They used to transfer, and this is very popular up north in Delhi and thereabouts. They used to transfer properties only on the basis of power of attorney. Then across board, all the states, everybody changed the article governing stamping of power of attorney. The minute you give anybody the power to sell a property, it is construed to be a conveyance. Of course, there are some exceptions, like I think if you give it to your mother, father, son, without consideration, then such a power of attorney may not. And remember, such a power of attorney will not be irrevocable either. So this is this is the bit I wanted to share about power of attorneys. As I said, as far as precedents are concerned, there are a lot of books on precedents. These are checklists. Each transaction is different. Each transaction is unique. We have to think through and decide what to incorporate in your, in your power of attorney, what not to incorporate in your document.
If there's 25 acres and they're sold to 5 different people, then who will get the title deed or the title document?
So the thumb rule is, and this comes from the Transfer of Property Act. Why can't I see who the speaker is? Anyways, this comes from the Transfer of Property Act. So in Transfer of Property Act, it's clearly given the person who has the greatest property will get to keep the documents.
Okay. So, but if it is divided equally among all the 5 people, then it will be a problem.
Yes, because each one would want the property. So probably the last person, or what we usually do is we take certified copies. Now, the sub-registrar of assurances gives certified copies. So when I say certified copies, I don't mean the notarized copies, true and self-attested by a notary. As far as real estate documents are concerned, the copy certified by the sub-registrar, because all these are compulsorily registrable documents, is as good as having an original.
Understood. And one more thing, the other question that I had in mind was when you said encumbrances, I kind of, if you could explain encumbrances again.
That clause which talks about encumbrances, isn't it?
Yes, yes, yes.
Against encumbrances. The caption of the clause was against encumbrances. Now, if you are the owner of the property, then it is, you're the purchaser. The vendor would know inside out about his property. No matter what you do, no matter how many title due diligences you can, conduct. If the owner has, for example, executed an MOU, how will you come to know? MOU is not compulsorily registrable under the law. How will you find out whether there is an MOU that he has executed, unless again after the sale deed tracked to the court? So in these cases, when you say encumbrances, it can be anything. The person, the party. So in case the party with whom the vendor has executed the MOU takes you, supposing I can see a name, Dave. I sell the property to you, but I had already done an MOU with Dave. So Dave will drag you to court saying that an MOU was executed in my favor, in which case you can invoke the indemnity clause. You can, of course, fight Dave on the basis of a registered document, and the court will decide who is right, who is wrong. But in the meantime, you can also, you would suffer. You can seek damages from me. So if supposing because of this fight, you're not able to set up your factory, you can quantify the loss you suffered and recover it from me. So that is against encumbrances. I've given you encumbrances of an MOU, which is very common. There may be an encroachment. When I tell you that I'm selling the land to you free, I'm giving you a clear title. See, the as is where is basis is a different ballgame. But when I'm telling you, because your price would be what you are paying me is for a clear title. Why would you live with an encroachment when you have paid the price for a perfect title? So that is the idea of encumbrance.
When you said the transfer of immovable property will only happen on payment of stamp duty, but what happens in case of a company which has a real estate company, incorporated company who has sold all its shares to a new owner? In that case, there is no payment of stamp duty on the land holding which the old company is having. That is my first question. So where does the question of paying stamp duty when the transfer of share takes place? And my second question is, say for example, if there are joint owners in the property, say for example, typically we see that in villages the property is registered in 7 extract in the name of elder brother, and if he sells it and if there are other heirs to the property, then what is the remedy for the other legal heirs? Those are my two questions, ma'am.
Okay, regarding your first question, you see, and I had this typical experience. People, every time there's, other corporate lawyers and all other lawyers feel that stamp duty is something which only real estate lawyers ought to be thorough with. In fact, stamp duty is attracted on every instrument. So in case of a shareholder share purchase agreement, there is a valuation done. In fact, the guidelines state that the valuation by a chartered the property of a company has to be valued by a chartered accountant, and a percentage is payable on the basis of that valuation. So it is not that if companies can get away with just transferring their shares and not paying any stamp duty. That is one aspect. The other is, and for this reason, the conveyance, the definition of conveyance too has been made. At one time, people used to have these merger and amalgamation orders. So the amalgamating, a company would take over another company only for the real estate. So there's an entire formula given under Article 25 or Schedule 1 as to how to deal with these kind of amalgamation orders. And if you see NCLT in these days makes it a point to state that this order has to be stamped as per. Recently, we were doing, sometimes your amalgamated company may have properties in Maharashtra, Gujarat, and other states, in which case it gets a set off, but it has to be stamped as per the valuation of each of the properties. So as I said, there is death and taxes. You can't do much about both the things. Regarding the other, there are many, in fact, Supreme Court judgments which say that revenue records they are not title documents. So the revenue records do not confer title on any person. So if the father has died and it so happens that only the name of only one of the sons is reflected, or one of the heirs is reflected on the 712 extract, he does not become the complete owner. So others can challenge it. It's very common. This kind of challenge is very common. We just dealt with such a property a couple of years back. Revenue records have just prima facie value. As far as vesting of rights is concerned, they are not documents of title, can be challenged. You can seek your remedies against the person who tried to defraud you, but the heirs will have a right.
What is the difference between a sale deed and a deed of conveyance?
See, the deed of conveyance and sale deed is the same thing. And we are asked this question on many times. I think once I had even given an opinion that it is one and the same thing. I prefer the terminology conveyance because you are conveying the property, which goes, according to me, which goes beyond just sale. But it's the same thing. Sale deed and deed of conveyance, there's no difference between the two. In fact, if you're doing a apartment, usually in flats, there is no deed of conveyance. So the accepted terminology is deed of transfer, because there are certain peculiar what shall I say, clauses in a deed of transfer. See, where a flat is concerned, you are actually buying membership in a society. So you have all those covenants regarding the society, saying that if there are funds to the credit of the standing to the credit of the seller in the society account, you as the purchaser will be entitled to those funds. So yes, these are just nomenclature. Essentially, they're the same documents. When you do then you have something called deed of apartment. So, apartment is usually in a case of condominium. So you have, for example, in Maharashtra, we have the Maharashtra Apartment Ownership Act, which prescribes a particular format for a deed of apartment. It prescribes a particular format for a deed of declaration. Yes, I hope that clarified your question.
Apart from stamp duty, there is also cess or other tax to be paid while executing documents. Oh, how one should know this, because these are local laws made by delegate authority, which are not properly published. So my question
I know
was,
we usually have this problem when, for example, we were doing a property in Raigad, and this was few years back when we thought 5% is good enough. But ultimately, after cess and this and that, it came to some 7 to 8%, and we were quite shocked. But, usually you don't give any commitment on figures unless if you may not have the time for adjudication. But you make it a point to send your clerk to the office of the sub-registrar of assurances and get at least get an informal opinion of the authorities on your sale deed. So, for example, in Bombay, I think because of COVID, that notification was put on hold of 1% cess. Now it has been brought back. So in addition to whatever you pay as the stamp duty, you have to pay 1% cess if your property is within municipal corporation limits.
okay, ma'am. Thank you, ma'am.
What should we look for when you have a facility agreement, like a loan agreement?
See, when you are examining a facility agreement, most of the financial institutions have their standard template. And I have had instances where we are seated across the table and the gentleman just got up and said, sorry, I don't even have the powers to negotiate these clauses. So it's actually similar to signing on the dotted line. But your sanction letter is one of the most important documents. Make sure that whatever has been agreed to in the sanction letter is reflected in your facility documents. Now, let me give you a very typical example. If you are a mall developer, you transferring leasing out of units to different brands, to different retailers. You may be a big mall and there may be Reebok, there may be a Nike in your. Now, all these brands ideally, a typical vanilla transaction, you would have to go back to the financial institution, take their NOC, and only then would you be able to let out your shops to different retailers. But you mentioned that these kind of transactions, you're a mall developer, are in the ordinary course of business. And because these type of transactions are in the ordinary course of business, you should not be required to go back to the lender, or if it's a very, if the lender is represented by a trustee, security trustee, go back to the security trustee and seek their NOC. So as I said, in financial banking and finance documents, I mean, besides first understanding the transaction and knowing a little bit of the law, what is most important is marrying the sanction letter. The sanction letter is not as voluminous. So making sure that there's nothing in the financial documents which is inconsistent with this sanction letter. The interest rates, sometimes you may agree to sell, say, for example, mortgage, only few of the floors, but the description given will be extremely vast. So then as a borrower, you can tell that this is the sanction letter and, this is what has been agreed to. And I hope that answers your question.
Ma'am, I have a question that if I have saw a property which was constructed 60 year back, and he is now selling that property, should I include the clause of this that it is 60 years old, and can I reduce the stamp duty of the property by this?
Yeah, you can.
Thank you, ma'am.
Ideally, they should give you benefit of all 60 years, but the stamp authorities have their own set procedures. But they, as a thumb rule, they do give up to 20 years. But if you mention that it's an old building, you will get depreciation.
I just had a question on the power of attorney aspect. I've just come across a deal where, say, 12 or 15 years back, there was some group of people who have purchased a land and they are given some irrevocable power of attorney to a person to develop it. And now, after 10 or 15 years, it has just happened that the person on whose name the power of attorney was executed, he has sold the land. So in that context, what is the remedy available for the people who have purchased it on their name? Because it was on their name, the 712 extract reflected all the names of all the 15 people, but they have executed a irrevocable power of attorney in favor of that person.
So, sir, in real estate, there is this concept, and transfer of property has specific provisions with respect to that. Bona fide purchaser for value without notice. So your entire case rests upon the fact that you are a bona fide purchaser for value without notice. If the other side can prove that you had notice and you were negligent, not taking searches, for example, is negligence. Usually, if it's been given to the developer, he will put up his board and he will take possession immediately. And possession is constructive notice. So if you therefore never buy property without visiting it, the other side may be able to prove that you were negligent. Mera to board hai. Everywhere you can see that I'm in possession of the property, yet you went ahead and without inquiring into the circumstances, you purchased the property. So I'm not to be faulted. So it will all depend on who is able to prove his bona fides. But the seller can, obviously, you can catch hold of the owner, the seller, for sure. He would know that he had done this deal and he's basically cheated you.
Okay, because this was some land development project, and since the person had the expertise in land development, all the 15% purchased the land and then they executed a power of attorney in the name of the person who was supposed to develop the land. So they were not aware of the irrevocable power of attorney aspect, and in spite of the land being sold now, there is no consideration which is being which is being given to the landowners. So in that respect, they don't have any remedy as such.
The landowners?
Yeah, because say 15 people, a group of 15 people purchased 15 acres of land and they have executed a power of attorney in favor of one person to develop the land and And invariably, they have not seen the document of the power of attorney, and probably it had a clause that the holder of the power of attorney can also sell the land, and eventually sold the land. but the 15 owners, they did not get a single rupee out of it. So what is the remedy available for these 15 people?
So these, as I said, everything will turn around bona fide purchaser for value without notice. The 15 people I refused must have been promised something by way of constructed area. Usually that is the case. Did they issue a termination notice? Why did they sit quiet for 15 years? All these things will be inquired into. Usually you know, a normal person would say that you have abandoned the contract, I'm revoking the power of attorney, and I'm terminating this deal. Have they done that? Or they have quietly on the sly?
No, because just now, after looking at the land records, when you go on the apps and all those things, they have just come across after so many years that the land has been transferred from their name onto the person's name who has the power of attorney. And so it's
why
almost...
did this, see, the owners now will have, as I said, each party will have to prove his bona fide, and this will, so the general law is, as I said, bona fide purchaser for value without notice. As far as the owners are concerned, they will have to prove that the other side abandoned the contract.
So the bona fide purchaser, you are saying that is the equities darling, you are saying. That is
yes, you will have to weigh in whose favor the equities operate. You never know. They may have been a fight amongst these owners. There must have been a court order. That's why they could not proceed with the...
There was nothing of that sort. It was a land development project. And since the person had expertise, he said, okay, you just purchase the land, give me the power of attorney, I will develop it for you.
See, I tell you, in the 1990s, instead of doing a deed of conveyance, which was very expensive, throughout the Article 5GA was amended in February 1990 to specifically provide for development agreement as a, as a fully, to be stamped as a conveyance. So throughout 1990s, what these guys used to do, they used to do development agreement, not have it registered. They very recently, I mean, the case law saying that a development agreement is a document falling under Section 17 of the Registration Act is of comparatively recent origin. So back then, 20 years ago, what people used to do a development agreement unstamped, unregistered, and give a power of attorney, because power of attorney, and back then even the power of attorney used to not be registered. The Registration Act in the context of the state of Maharashtra was amended in 2013 on account of these frauds to say that forget, let alone a power of attorney for sale, which is your power of attorney, even equitable mortgage, which elsewhere in the country, an equitable mortgage need not, the memo of entry need not be registered. But because of all these fraudulent cases, Maharashtra government amended the Registration Act and said both memorandum of, this entry in an equitable mortgage as well as a power of attorney giving powers to sell, both of them have to be compulsorily registered.
So in this case, if the power of attorney is, say for example, if the sale happens post 2013, and if the stamp duty is not paid on the power of attorney itself, then can we set aside the sale transaction?
Yeah, because that would be the evidentiary value of that power of attorney if it's happened after 2013. It cannot be relied, it would have no evidentiary value. See, sir, I think the owners have approached you. From the looks of it, the owners are being very naive and not telling you the real transaction. They must be having a development agreement in their favor. And remember, real estate, the biggest problem with real estate is cash. They must have taken some cash element.
I don't think so, because unfortunately, I'm one of the owners.
Okay.
So I know the things, and we know the person very well. We were knowing the person who was doing it. So it was out of faith that we have entrusted him with the power of attorney. The power of attorney was executed.
So can you sum up the question? Sorry, sum up your entire query because we need to wind up. Yeah, it's past 7. Yeah.
So, sir, I actually agree with Malvika. Yours is it's not a general query. It's very specific to a problem, a situation that you're facing. As I said, here each party will have to try and prove his bona fide. The purchaser, the owners will have to prove their bona fide by saying that this fellow had abandoned if there was a contract, that we had terminated it. And frankly, for a very peculiar situation, this corridor consultancy is not advisable.
Yeah. Okay, absolutely. Thank you, ma'am. Thank you.
Thank you, sir. Thank PLEA for again giving me this wonderful opportunity.